Welcome all. Today we have with us one of the very famous lawyers of Madras High Court, Mr. P.B.Balaji, and my good friend. Mr. Balaji has completed his 5-year integrated law course in the prestigious Madras Law College and finished it in the year 1996. He enrolled himself in the year 1996 and has been practicing in the Madras High Court since then, close 25 years. And he has been a civil lawyer for his own name and fame, and his specialty and special area of practice is law relating to property, contracts, rent controller, and succession laws, besides conveyancing. He has been part of the editorial board as an associate editor of the current Tamil Nadu cases group of law journals that brings out approximately 6 weekly journals regularly. And he has been a regular visiting faculty resource person at the Tamil Nadu State Judicial Academy. And his name is etched in the record of the history as he has co-authored the very famous book called the Tamil Nadu Buildings Lease and Rent Control Act 1960. And he has also contributed in the matter of writing articles relating to law in Times of India and the Hindu. Besides his academic credentials, he has got one passion and hobby, that is photography. He is a freelance photographer who has an accreditation with the International Cricket Committee, and he covered the 2015 Cricket World Cup that was played in Australia and New Zealand. There are enough credentials which are like the feathers in the cap. And with this, I introduce Mr. Balaji to the audience. Before going to the session, I wholeheartedly welcome the honorable judges who are present today in the webinars. That includes the judges of the High Court and judges of the subordinate judiciary, all the senior counsels, all the advocates, and my young beloved judges. And I welcome everybody to this session. Now it is over to Mr. Balaji. Mr. Balaji, please proceed.
Thank you, sir. Very good morning to all of you. I think all of us expected much relief from the lockdown, but unfortunately, it doesn't seem to be coming. So when my good friend, Mr. Srinivas Raghavan requested me, why don't you talk about specific relief act? I said, why not? I will at least give you some specific relief today. So coming to the subject, what is specific relief? Specific relief is a relief in specie. In other words, as the name suggests, it means specific relief or exact fulfillment of the obligation under a contract by taking recourse to judicial redress in a court of law. This is what is called specific relief. Salvant, the famous author, in his book Jurisprudence, defined right as an interest recognized and protected by a rule. It is any interest in respect of which there is a corresponding duty, and disregard of the same amounts to a wrong. We can probably broadly categorize rights as legal, moral, social, religious, and other categories. A legal right is an interest protected by law, and if such a right is violated, it will be construed as a legal breach or infringement, as we call in legal terms, which entitles a person to seek legal remedy. To the contrary, rights like moral, social, religious are not recognized under the law. But breach of those also will amount to a breach of moral duty, which probably, depending on the facts of each case, will entitle the person to approach probably a writ court and seek equity on the grounds of principles of natural justice, etc., etc. But today we are concerned with the legal remedies available with specific relief act. So therefore, there are two kinds of rights, as we saw. Next will be how did the act come into force? This 1963 act is not new to India. The specific relief is not new to India. 1963 was not the first enactment. Even in 1877, the specific relief act was introduced for being an act to amend and define the laws pertaining to certain kinds of relief. In 1963, with some changes, the Law Commission's report was accepted, and the 1963 Act was adopted and came into force in 1964. Gazetted in December 1963, and it came into force in March 1964. Interestingly, if you see, both the preambles to the 1877 Act as well as the 1963 Act clearly say it is an act to amend and define the law relating to certain kinds of specific relief. So here straight away, if you see, the operation of the act is restricted to certain kinds of relief, not all kinds of specific relief. The origin of specific relief can be traced naturally to the courts of England, courts in England, especially the courts of equity. If you all remember, the Contract Act was enacted in 1872. The Contract Act provides for damages in case of breach. The courts of equity probably felt that in many cases, mere award of damages or compensation is not going to be adequate relief to the party, to the aggrieved party. And they formulated doctrines of equity, which forms the basis of the Specific Relief Act. In 5 years down the line, the Specific Relief Act 1877 was enacted. In 1963, with not much change, Section 9 was introduced. Section 42 was retained as it stands today. In all other respects, the Law Commission's report was accepted, and 1963 Act has come into force. Then this 1963 Act has held field for almost close to 60 years. In 2018, there have been drastic amendments. The nature of amendments are substantial. Let us examine them in a short way. But before that, let us see the objects and statement of reasons why the 2018 Act came into force. The amendments were necessitated. See, the government felt an urgent need to revisit the old law of 1963, since the economy was very robust and there were enormous commercial economic activities in the country. Discretion of courts to grant or refuse specific performance was very wide, which they wanted to curtail. They wanted to cater to a separate set of projects, which is called infrastructure projects. A new concept of substituted performance has been introduced in Section 20. And to fast track cases with regard to infrastructure projects, these are the major objects for which the 2018 amendment was given. And in fact, on 1/10/2018, the Amendment Act has also come into force. This interestingly now takes us to the question whether the amendments are retrospective or prospective. See, normally in many amendments, if we notice, the Act itself will indicate whether it is going to be retrospective or prospective. But in the Specific Relief Amendment Act of 2018, there is no such mention as to whether the Act is going to be of prospective application or retrospective application. So now, naturally, we'll have to look up the judicial pronouncement in this regard to find out how the matter should be approached. There are many angles from which the subject can be approached. Number one, as is always said, the procedural laws are always retrospective and substantive laws are prospective in application. The Specific Performance Act, the Specific Relief Act has always been viewed as a procedural law because the substantive law is the contract law. The Indian Contract Act is the source of the remedy is in the Specific Relief Act, the substance is in the Contract Act. Therefore, the Supreme Court, in fact, up to 2007 also they were of the view that the Specific Relief Act is only a procedural law. So if we view it from that angle, we must only say the amendments will be retrospective. But there is a contra view possible. Let us look at the nature of the amendments. The amendments which have been brought inside are very substantive in nature. A new concept of substituted performance has come into play. Infrastructure projects, discretion of courts is now drastically reduced in the amendments. So it is not a mere clarification or corrections made in the by way of amendment, but substantive changes. So if that is the view taken, we may probably have to say the Act will only be prospective, not retrospective. In fact, there is another view which we can take is the application of Section 6 of the General Clauses Act. Section 6 of the General Clauses Act preserves the rights which have already accrued to a party. So therefore, if from that angle, if we view this legislation amendment can only be viewed as a prospective amendment. Interestingly, this issue has knocked at the doors of the Honorable Supreme Court on several occasions. Earliest was dealing with the cases of Benami Prohibitions Transaction Act, where Section 4, as you know, it does not entitle a person to hold property benami. There is a prohibition. So Section 4 was put to test in the Honorable Supreme Court. In the first view taken by the Supreme Court was the Act is retrospective in nature. It will apply to pending proceedings also. I'll give you the case law in a second. The earliest case was it will be Kumari versus P.B. Kare. Kumari versus P.B. Kare, which is reported in 1989, 2 Supreme Court cases, page 95. The Supreme Court said it will apply even to pending proceedings. But much later, a larger bench of the Honorable Supreme Court in Rajagopal Reddy versus Padmini Chandrasekharan, 1995, volume 2 Supreme Court cases, page 630, held that the Act can only apply prospectively. They overruled the two-judge bench judgment in Kumari's case. In fact, they coined a new word called retroactive. It is neither retrospective nor prospective, but probably we should say a via media approach. So it will apply to proceedings depending on the date of institution of the suit. So this retroactive principle was coined by the Honorable Supreme Court in 1995. There is another important ruling in 2012 in Bajpayee's case. Bajpayee versus Union of India in 2012, volume 4 Supreme Court cases, page 653. The Supreme Court said, no doubt we have been adopting the test to find out whether an act is of prospective application or retrospective application by seeing the nature of the act, whether it is substantive or procedure. But Supreme Court in this case said it is no longer good or proper to adopt such an approach. Let us look at it from a different angle. There is march of law. Therefore, it is necessary that we should look at it from a different perspective altogether. So they said abandon the test of the nature of the amendment or nature of the law being substantive or procedure. Adopt the two-test method. One would be look at the nature of amendments. What are the nature of objects of the amendments? Are it substantive or it is only procedural? And number 2, test the fairness of the amendment. Both these, if you are able to put it to test, you will get the answer whether it is prospective or retrospective. So I think it will be better to take an illustration to examine this position more clearly. A suit is filed by X before the Amendment Act came into force. That was, say, in 2016, he files a suit for specific performance of a contract against Y. In the plaint, he fails to plead readiness and willingness. We all know, before the amendment, under Section 16C of the Act, it was mandatory to plead readiness and willingness. Averment was mandatory, and failure to amend is getting on judgments of our court, division bench, Supreme Court, that the suit has to fail. So in this case, fortunately, unfortunately, the plaintiff had not pleaded readiness and willingness. The defendant promptly took up the defense and said the suit has to be dismissed in limine. 16C has not been complied with. There is a failure, and therefore we have to get the suit dismissed. Pending suit, the Amendment Act comes into force in 2018 October. Trial is going on. So now, after amendment, the requirement to plead is taken away. There is no necessity to our readiness and willingness. It is enough if the plaintiff proves readiness and willingness. So now let us suppose we say the act is retrospective, the amendment is retrospective, then the plaintiff need not prove readiness and willingness. He need not have a readiness and willingness, he only has to prove readiness and willingness. So does it not take away the right vested with the defendant to get the suit dismissed? So this is the test of fairness. The right which is already accrued to the defendant by way of the written statement, the defense he has taken, that there is mandatory plea has not been taken in the pleading, in the plaint, the suit has to fail. So that cannot be snatched away from the defendant. So this is one test of fairness we can apply. The second one is the nature, as I told you, the nature of amendment, the purpose of amendment. We already looked at the nature of amendment. They are very substantive in nature because substituted performance, new concepts, it is not merely clarificatory or declaratory. They are substantive in nature. New concepts are introduced. Therefore, both the tests we should, if we apply, we would only have to hold it is either prospective or retroactive, as the Supreme Court said. In fact, in another IndusInd Bank's case much later, in 2016, 9 SEC, page 720. I'll give you the judgment. 2016, volume 9 Supreme Court cases, page 720. It is Union of India versus IndusInd Bank. There, section 28, which is amended to the Indian Contract Act, was put to test. The Honorable Supreme Court said it's a substantial amendment, taking away rights which was originally vested with the party under the old act. Therefore, we cannot give it retrospective operation. We have to treat it only as a prospective operation. So, keeping in mind the ratio laid down in Bajpayee's case in 2012, and which is more or less followed in 2016 while testing the section 28 amended provision to the Contract Act, the Supreme Court has now probably taken the view that the test is no longer the nature of the law, but apply these two tests: the nature of the amendment, the object of the amendment, and the test of fairness. So, but it is only my view. My view, it is retroactive, because there are articles to the contrary which I have read in magazines which they say it is only a procedural law still. Therefore, it has to be applied retrospectively. It is my view that it is going to be retroactive or prospective, but we'll have to wait and see, because none of the courts have had an occasion yet to deal with this aspect as to whether the amendments, especially the matter goes to Supreme Court maybe about 5-6 years down the line. The High Court maybe will decide 2-3 years later when it appropriate case comes before it. So this is the position, whether it will apply retrospectively or prospectively. Then we will also now go back to the preamble for a moment. As we saw, it applies only to certain kinds of specific relief. So is the application of the Act exhaustive? In Hungerford's case in 1978 Supreme Court, the Supreme Court, I will give you the citation, 1972 Supreme Court case, AR 1972 Supreme Court, 1826. The Supreme Court, referring to the preamble of the Act, held that the Specific Relief Act of 1963 is not an exhaustive amendment, not an exhaustive enactment. It does not consolidate the whole law on the subject. Therefore, it is very clear that the Act, probably we can say, insofar as matters that are dealt with under the Specific Relief Act, the Act is exhaustive. For example, if you take, even under the CRPC, section 145, where a person is forcibly dispossessed, he has got a right to recover possession of the property. He can approach under the Code of Criminal Procedure. So that is also a kind of specific relief. Let us take the example of a Trust Act, where trustees have obligations. In Transfer of Property Act, coupled with the Code of Civil Procedure, rights of mortgagor and mortgagees are set out, their rights, redemption rights, all these are specific reliefs which are obtainable in civil courts. So all reliefs which are obtainable in civil courts are not covered under the Specific Relief Act. It is only certain kinds of reliefs. In fact, for example, even the Trademark Act and the Copyright Act, there are injunctions which can be granted under the provisions of those acts. Even labor laws, reinstatement, back wages, they are all specific reliefs, but they are not governed by the principles of the Specific Relief Act. Therefore, as the preamble rightly says, it is an act to amend and define only specific kinds of relief, certain kinds of specific relief. Now, let us come to the Act itself. So, I am going to highlight basically the amended provisions today, because the Act is very exhaustive, and we had a benefit of an excellent lecture by Mrs. Chitra Sampath a couple of days back, where she took us to suits for declarations, injunctions, leaving out specific performance, which I am today going to deal with more focus. More focus will be on specific performance, which Mrs. Chitra Sampath did not touch, because she knew I am going to talk today about this. So let us see how the Act has been framed. The 1963 Act has 3 parts and 8 chapters. The first part consists of 4 sections. It is called preliminary. Preliminary first section is the short title, extent and commencement of the Act. Section 2 sets out definitions of important concepts. Section 3 is a saving clause. Section 4, it sets out that specific relief is to be granted only for enforcing individual civil rights and not for enforcing penal laws. The second part has 6 chapters. Section 6, section 5 to 8. Section 5 to 8 deals with recovery of possession of property. Chapter 1, that is chapter 1. Second part has 6 chapters. First chapter is sections 5 to 8, recovering possession of property. The second chapter deals with specific performance of contracts, sections 9 to section 25. The third chapter has one section which deals with rectification of instruments. The fourth chapter deals with rescission of contracts, section 27 to 30. The fifth chapter, sections 31 to 33, deals with cancellation of instruments. And chapter 6, sections 34 and 35, deals with declaratory decrees. The last and third part has two chapters. Chapter 7 is sections 36 and 37, which deals with injunctions generally. And chapters 8, the last chapter, deals with section 38 to 44, which are perpetual injunctions. There are various kinds of specific reliefs under the Act. We can probably categorize them as positive and negative. So except perpetual injunctions or injunctions where a restraint is called for or requested for from the court, all the other reliefs can be termed as positive. Even a mandatory injunction is a positive relief. A decree of specific performance is a positive relief. Am I audible?
No, of course, you're audible, sir.
The video, something happened to the video.
No, I'll just disable
Okay.
the screen sharing. Okay, sir. Now you can go.
Yes. All the other reliefs are positive. Cancellation, rescission, and specific performance, declaration, all these can be categorized as positive reliefs, specific reliefs. The other only negative is the perpetual injunction, where a negative injunction is sought for. Now let us go to section 6 straight away. I am going to deal with only important sections which have been amended. I've already given a preface note yesterday as to which sections have been amended. So mainly I will be dealing with these amendments and the effect of them henceforth. So section 6, there is a very minor clarificatory amendment. Section 6, as you all know, is a special remedy available for recovering possession. The very characteristic feature of this section is that a person with no title can ask for repossession. Suppose a tenant, for example, a tenant is dispossessed from the property by the landlord, except by the due process of law. He can invoke section 6 and ask for recovery of possession. But the suit has to be filed within a period of 6 months from the date of the date of disposition. The actual date of disposition, time limit is only 6 months. The suit is not maintainable against the government. So government has got the king is sovereign, so government can dispossess any person by way of acquisition or otherwise. You cannot come under section 6. Probably you have a remedy in the writ court, but you cannot invoke section 6 and seek for recovery of possession against the government. Now section 6, there is a minor amendment which includes a person who is dispossessed. Now a person through whom the person is dispossessed is also enabled to come before the court and seek the relief of section 6, recovery of possession. That is the minor amendment in section 6. Section 7 and 8, there are no amendments. They deal with recovery of movable properties and delivery of movable properties by a person in possession, not as owner, and how they are entitled to recovery of possession immediately. Section 9 is a new section under the 63 Act, which was not available under the 1877 Enactment. Section 9, again, as we say, now we are moving on to part 2. Section 9 to 25 are dealing with specific performance of contracts. Section 9 enables, that is the first section in chapter 2, which deals with a defense which can be set up by the defendant in a suit for specific performance. So section 9 enables the defendant to raise any defense that would be open to a person to take in any law of contracts. So it basically absorbs the various provisions of the Contract Act fundamentally. So the pleas like undue influence, fraud, coercion, misrepresentation, all these can be taken in a suit for specific performance as a defense. So this is section 9. Section 10 has been amended. Section 10 has been amended with a new section with the heading specific performance in respect of contracts. Originally, it was cases in which contracts, specific performance of contracts enforceable. The heading was section 10. Originally, before amendment, cases in which specific performance of contract enforceable. Now, section reads specific performance in respect of contracts. Old section 10 gave a discretion to the courts to grant the relief of specific performance if it felt that compensation was an adequate remedy to make good the loss, and specific performance only if such damages could not be asserted. However, now the new section especially employs the word shall in the place of may. And probably that is the reason why even the heading has been changed. The heading previously, if you see, I will repeat, specific performance in respect of contracts is now the present heading. It replaces the old heading, cases in which specific performance of contract enforceable. So that heading now gives way to specific performance in respect of contracts. So this is in line with the object of the amendment to do away with the discretion of the courts. And by employing the word shall in the place of may, it is very clear that the court's discretion is now whittled down. The exceptions given to section 10 are threefold. So normally a court shall grant specific performance in a suit subject to section 11(2), section 14 and section 16. So we will go to section 11(2) straight away because it is the next succeeding section. 14 and 16 we will discuss when it comes. Section 11 deals with specific performance of contracts with trusts. 11(2) is an exception where a trustee acts in breach of his powers. Then he cannot get, the contract cannot be enforced specifically. So that is an exception. So 11(2) is an exception which is brought inside 10. So if it is in breach of a trustee powers granted to a trustee, then that contract cannot be enforced. That is one exception which is carved out in section 11 subsection 2. Section 12 deals with part performance of contract. In fact, the section states that specific performance of part of a contract shall, it starts with the negative. It says specific performance of part of the contract shall not be granted or directed to be specifically enforced, subject to instances set out in subsection 12(2) to 4. So 2, 3 and 4 are exceptions to section 12 where part performance can be granted. Number of people now confuse this part performance with in TP Act, section 53A TP Act. Specific performance of a part of a contract and not 53A are operating in totally different fields. See, here you want part performance of a contract. There is a contract. You want to perform a part of the contract, that is section 12 of the Specific Relief Act. But section 53A deals with a person who is already in possession in part performance. So a person who is already in possession in part performance of a contract is discussed in section 53A. What is this, right? That is under 53A. Though, therefore, there is no confusion. Section 12 is coming to court seeking specific performance of a part of the contract, whereas section 53A operates in an entirely different field. I find a lot of even advocates are getting confused with this part performance and part performance of a contract. Then what, suppose, let us take an example where a person who does not have full right to the property. He has only an undivided half share in the property. He includes his father's share, other remaining half share, and enters into a sale agreement for the entire property. So when the matter went up to the Honorable Supreme Court, and our High Court has also consistently taken this view, insofar as the person who enters into the agreement representing it to be the entire property as the subject matter of the agreement, he is bound. He cannot take advantage of his own wrong and say, no, this is amounting to part performance hit by section 12. He cannot do it. Insofar as that person is concerned, it is a whole contract. To read the contract as a whole, insofar as his half share is concerned, is what the Supreme Court says. I'll give you one leading case, which is Kamanna Sambamurthy versus K. Achyutamma, which is reported in AR 2011 Supreme Court 103. You want an equivalent, it is 2011 One Law Weekly, page 104. This is a leading case where they said, assuming you are not the owner of the full property, you have committed to selling, so you cannot wriggle out of the contract. Your half share should be treated as the whole of the contract. You cannot avail the benefits of section 12 and say it amounts to part performance, dismiss the suit. This is what the Supreme Court says. Then section 13. There are another instance of subsection 12. We can probably the part of the contract. Suppose the contract is a divisible contract. The part of the contract is found to be segregated from the major part. Suppose you can cull out one portion of the contract and it can be specifically enforced. That also can be enforced, is what the court said, which is also the letter and spirit of section 12. Section 13 is a right of a purchaser or a lessee against the vendor or lessor who has no title or imperfect title. This, we have all read in law college the concept of feeding the grant by estoppel. Section 43 of the Transfer of Property Act will straight away apply here. So what happens if a person who has no right or title, either knowingly or unknowingly, enters into an agreement and subsequently acquires the right? Let us take an example. A similar case where a son wants to dispose of the entire property, but he is entitled only to half share. The other half share belongs to his father. He is the only son. Mother had predeceased. Therefore, but after the contract, the father dies. His half share blossoms into a full 100%. In such cases, Section 13 gives a right to the purchaser, the agreement holder, to come to court and say that now that you have got full right, please compel him to execute the contract. That is Section 13. It includes the power of compelling not only the person, but also other persons who may be required to give good and marketable title. That is Section 13. Section 14 is again amendment has been 12 and 13. There are no amendments. Section 14 there are substantial amendments. Old 14 has been totally replaced with a 14 and 14A, 14 capital A. So the heading is still the same. Specific performance, contracts not specifically enforceable. So now remember Section 10, exceptions 11.2 we saw. This is the second exception, Section 14. Section 11.2, 14 and 16 are the only exceptions where the court shall not, word shall, otherwise it shall grant specific performance. So what is 14 now? 14 earlier also dealt with contracts not specifically enforceable. Now the amendment provisions mandates refusal of specific performance in 4 instances. A, B, C, D. The first instance is where it will refuse specific performance if the party has obtained substituted performance of the contract under Section 20, which we will come to a little later. Then the second one is contract which involves a continuous duty which the court cannot supervise. This is available even under the old 14. 14B to D are the same. There is no change. The first one where substituted performance is introduced, old 14A has been taken, which where compensation was an adequate relief, the court will not grant specific performance. That has been now removed in line with the object that discretion should not be there with the court. The old 14.1A where compensation was adequate to the party instead of specific performance can be refused, has been now substituted with a party who has obtained substituted performance under Section 20. 20B is contract which involves a continuous duty which the court cannot supervise. For example, it is a contract where the owner gives it to a building contractor to build a bungalow with very minute specifications and many terms. This is a contract which will involve continuous duty of the court. It can't enforce such a contract. That is what 20B says, where it involves minute details and continuous duty of the court to monitor the performance. It is not possible to specifically enforce. That is Section 14.2, 14CB. Then C is a contract which is dependent on the personal qualifications of the parties such that it cannot enforce specific performance of the material terms of the contract. So when the contract, so suppose it relates to a performance by a Carnatic vocalist, it involves the personal qualification of the person. So those contracts again cannot be specifically enforced. And contracts by in its nature which are determinable. So the parties themselves agree that we will put this agreement to an end on such and such an event happening. Then in such cases also the court can refuse specific performance. So this is the only difference is the substituted performance is replacing the discretion with the court which was given to the parties. Section 15, 14A. 14A is now newly inserted. It empowers the court to take the assistance of experts. So experts to assist the court on specific issues. Now the court can take the assistance of expert engineers or forensic department experts or whomsoever, any experts in any field. If the subject matter warrants, the court has now the power under 14A, which is probably we should like what we do it in CPC. Take the power of the expert under for commission under Order 26 or expert evidence under the Evidence Act Section 45. So all these are now available to a court dealing with specific relief matters also. Section 16 deals with personal bars to relief. There are very important amendments to Section 16, which we will see. The section deals with categories of persons in whose favor specific performance can be enforced. 14, we saw contracts which cannot be enforced. Here, persons who are entitled to enforce a contract for specific performance is Section 16, in favor of whom specific performance can be enforced. So here again, substituted performance is now brought in. A person who has chosen to take substituted performance is a person against whom, in favor of whom specific performance cannot be granted. Then Section 20, the other categories are a person who has become incapable of performing or violates any essential term or willfully at variance with or subversion of the relation intended to be established by the contract. So these are the categories which are cases where the court shall refuse to persons specific performance because of their conduct. They have acted in fraud or suppressed material facts, or they acted in variation of the original contract. All these are instances under Section 16 apart from the specific performance, the substituted performance being obtained. So there, 16C, there's a very important amendment. We already discussed when we were dealing with the nature of the act, whether it is just of retrospective or prospective application. But Section 16C, which originally had the words fails to aver and prove, is now only prove, fails to prove. So the averment, the focus on the pleading is now taken away, and what remains is only proof. If the plaintiff comes to court and proves that he has been ready and willing to perform his part of the contract, he will be entitled to specific performance. Earlier, you not only have to plead, but also prove. So the focus on pleading is now no longer there after the amendment to Section 16C. Even in the explanation, which requires the plaintiff to establish proof of performance or readiness and willingness to perform the contract according to its true construction, this is the explanation. Words must, aver is replaced with must prove. Therefore, the shift is from pleading to proof. The earlier pleading and proof, now it is only proof. Concepts of time is the essence of contract, and readiness and willingness of contract will be undergoing drastic changes in the coming years, because the Amendment Act will have to be soon applied. As I told you, it will be applicable on the date of the institution of the suit. So the contract may be before the amendment, but if the suit for specific performance is filed after 1/10/2018, in my view, it is only the new act with the amendments that will apply to such a suit. In all pending suits, the old provisions, the unamended provisions will apply. So therefore, Section 14, readiness and willingness under 16, and whether time is the essence of contract are two major concepts which have time and again gone up to the Honorable Supreme Court, which have tilted cases. These two concepts are so vital in the suit for specific performance, whether the time is the essence of contract, whether readiness and willingness has been exhibited by the plaintiff, what he has to do to exhibit readiness and willingness throughout. All these are matters which have been taken up to the Supreme Court. Even up to 2019, there are cases which you will find under these two concepts. So readiness and willingness will have to definitely undergo a change, because we have seen suits being dismissed on the ground that the pleading has not been proper. The mandatory requirement of pleading readiness and willingness, suits have been dismissed for non-compliance. Therefore, this will naturally undergo a change. So insofar as time is the essence of contract, the law was settled, I would say. I won't say it is settled. The law was settled that in respect of immobile properties, the presumption is always that time is not the essence of contract. But contrary to the presumption, the parties may enter into a contract making time the essence of contract. So if it will be very simple. If your agreement does not say anything about time being essence of the contract, there will be a presumption that time will not be the essence, because it relates to a contract for sale of immobile property. But suppose the agreement specifies time is the essence of contract, and there are clauses which indicate that parties had intended to enforce the agreement on time, then the courts have said time should be the essence of contract. So the earliest case is a Constitution bench judgment in Chand Rani versus Kamal Rani. Chand Rani versus Kamal Rani in 1993, Volume 1, Supreme Court Cases, page 519. the Supreme Court held that no doubt there is a presumption that time is not of essence in a contract for sale of immovable property, but the party has to come to court in reasonable time. He cannot take his own sweet will and time and say, I have 3 years time from date of refusal, or law gives me 3 years. Article 54, I have 3 years to come to court. Therefore, you give me a specific performance coming at the fag end. The court said, no, you come within a reasonable time. What is reasonable time? It will depend on facts and circumstances of each case. The Supreme Court in the Constitution judgment set out 3 conditions. One, you look into the express terms of the contract to find out whether the parties intended that time should be the essence of the contract or not. That is the first condition. The second condition is nature of the property. Nature of the property. Now, the third condition is on the attending or surrounding circumstances. Now, let us take an example. A person is in dire need of finance to celebrate his daughter's wedding, which is in 2021. So he enters into an agreement in 2020 to sell the property, saying that this sale is only to augment funds to celebrate the wedding of the vendor's daughter. In such a case, the intention of the parties, the attending circumstances will lead to the conclusion that time definitely was made the essence of the contract. But of late, the Supreme Court has taken a different route altogether. In fact, even in 2011, in Sarda Mani Kandappan's case, Sarda Mani Kandappan versus S. Rajalakshmi, AR 2011, Supreme Court 3234. The Supreme Court observed that it is no longer necessary to hold such a presumption, to continue to hold such a presumption that time will not be the essence in contracts for sale of immovable property, especially considering the steep rises and fluctuations in property prices. They observed even in 2011 that this aspect has to be revisited. The same position has been reiterated in AR 2018 Supreme Court, AR 2018 Supreme Court 340 in Ramatlal versus Mardullah. So where again the Supreme Court said the position needs to be reviewed in an appropriate case when it comes before it. So now that the amendment has come into effect, I'm sure the Supreme Court in the case before it touching this point, the Supreme Court will take a contra view that you have to presume. There is no presumption that it will not be time the essence of contract. That is in fact the object of the amendments also. So if the Supreme Court is going to decide based on the amended provisions and also with regard to its earlier observations in Sarda Mani Kandappan and the Ramatlal's case, it is very likely that very soon the position will change and the Supreme Court is most probably likely to say that there should be a presumption that time will be the essence of contract in a suit for specific performance. This is insofar as section 16. Section 17 and 18 disentitle a person. I'll bracket 17 and 18 together, but they have a common factor. Section 17 disentitles specific performance of a contract to sell or let in favor of the vendor or lessor. So it is a case where the vendor or lessor seeks specific performance. Don't confuse it with the regular suits of purchaser or lessee coming to court. The section 17 says disentitles specific performance in favor of the vendor or lessor who has no title to the property, and such a person contracts knowing that he had no title or entered into a contract believing he had title but did not have title to market at the time of the proposed execution. So here the principle is a person cannot take advantage of his own wrong. So this is the fundamental principle which probably is the thread you should follow in section 17 and also section 18. Section 18 says where the defendant sets up a variation and the plaintiff cannot obtain performance except the variation set up, which is novation. We know the concept of novation. Originally there was a contract. The parties acted in contravention either expressly or impliedly or entered into a different supplement agreement which totally gave a new twist to the old terms, go by to the old terms. A new contract came into existence. It is called novation. So where the terms are agreed or varied, section 18 deals with such cases where defendant sets up a variation and says that the plaintiff cannot obtain performance except with variations set up. So suppose the defendant accepts the variation. He says, okay, it doesn't matter. I will accept to this change also. Then that contract is specifically enforceable. Because here the plaintiff is at fault. We saw section 18 where the defendant was at fault. He had no title. He conveyed title. He tried to convey title. But here the plaintiff tries to deviate from the terms of the contract by way of fraud, or they decide to give a certain result which is not possible because of various subsequent events, or the parties themselves have varied the terms by novation. So these are the cases where section 17 and 18 specific performance should not be granted. Section 19 is the category of persons where against whom specific performance can be enforced, may be enforced. We saw section 15 in favor of persons, specific performance can be granted. Is person in favor of persons against whom specific performance can be granted is section 19. These are contrary provisions dealing with both sides of the coin, basically. Section 20 is the most important amendment in the entire act. What was originally discretion vested with the courts under old section 20 is now substituted with contracts of substituted performance of contract by substituted performance. Section 20 is a totally new concept which was unknown to the earlier scheme of the entire Specific Relief Act. What is substituted performance of the contract? So section 20 now says the contract can be specifically enforced on refusal by the defaulting party. It gives the person at the receiving end to perform the contract that has been broken by the other party through a third party or his own agency and recover the expenses and costs actually incurred, spent or suffered from the party originally committing breach. So this is a novel concept which the legislature has brought inside the act. Substituted performance of a contract. The name may be a little misleading. See, I have also given a lot of thought. I still have my own doubts with regard to the implementation of this section to certain kinds of cases. So I'm going to think aloud today and discuss with you. So let us take a case of a mobile asset where I want to buy 100 bales of cotton from a company in Gujarat. So I enter into a contract with that person. He defaults. Then I opt to get substituted performance of the contract to a third party. Then I go to Bombay. I can get this contract which I had with the Gujarat dealer and get it enforced, substituted performance through a third party. Whatever expenses I incur, costs I incur, I can recover it from the Gujarat dealer. There is no difficulty. But here again, you cannot perform the same contract. The words substituted performance of contract is in a way misleading, because contract between me and the Gujarat dealer, that contract is set aside for the moment. I enter into a separate contract with a fresh dealer in Maharashtra and complete the performance. So that is what the legislature intends by saying substituted performance of a contract with a third party or through your own agency. So the option is given to a defaulting party, the party who suffers, to by account of breach by the other party, to have the contract performed through a third party or by his own agency. You cannot perform the same contract. He has already committed breach. So there is no question of performing the original contract. There is an option given to you to have substituted performance through a third party, and a new contract has to necessarily come into existence. So this is substituted performance insofar as movable properties are concerned. There is no difficulty at all. And before that, I will take you to the sections 20, which says you will have to give a notice. Now it is mandatory to give a notice under section 20, subsection 2, because you are going to totally abandon the contract and have it performed with a new party. The act now enjoins a duty on the plaintiff's part to give a notice to the defendant. 30-day notice, written notice has to be given, setting out clearly that you have refused. In spite of you are going to continue to refuse, I may have to obtain substituted performance through a third party or through a different agency, who is my agency, whatever. You have to put him on notice. So only if you satisfy the requirement, the mandatory requirement of putting the defendant on notice by a 30-day written notice, you can opt for substituted performance, not otherwise. So this is mandatory. So at least an option is given to the defendant, putting him, tell him that here I'm going to opt for substituted performance under section 20. You better complete your obligations before 30 days. So that is section 22. Then the proviso says, unless you have the substituted performance obtained from a third party or agency, you are not entitled to the costs or expenses from the party committing breach. So you can't give a notice and say you give me cost. You will have to first give a notice. If the breach continues after the notice period of 30 days, you have the option of substituted performance. You perform the contract by way of substituted performance, then recover the costs. That is the provision. And interestingly, once you have obtained specific performance by substituted performance, you have to give up the relief of specific performance against the original party in breach. Of course, you can, 24 says you are entitled to compensation or damages. You can still recover compensation or damages, but your right to specific performance of the original contract goes. So virtually you will have to give up your right for specific performance if you are going to opt for substituted performance. These are the conditions now which are available under section 20, newly amended 20. Now let us keep this in mind and take an example of case of immobile property. I want to buy a property in T Nagar where my children are studying. So I want a property which is very close to the school. Ideally for the next 14, 15 years, I need not move out, so it is comfortable for the family. So I go and enter into a contract with a person who owns the property very nearby to the school. The contract is breached. I give him the statutory notice under 22. The breach continues. So that gives me a right to substituted performance of the contract. In such cases of immovable property, how does it work? No doubt, I can identify another property and have this. That is why I said the same contract can never be performed. You will have to keep it aside for a moment, create a contract with the third party, enforce that, come back to the person in breach and say, I have performed substituted, I have obtained substituted performance, please give me costs and expenses. So that is, in case of immovable properties, it is going to be a challenge. I have to go through the entire process of identifying a property which is suitable to me, negotiate the price, enter into a contract. So what happens if that person defaults? Suppose I opt for substituted performance. The new vendor also commits default. So I can't be running around in circles. So when it comes to immovable properties, it's going to be a little dicey. We will have to, of course, it is a very novel concept. The legislature has definitely put a lot of thought into it before bringing about this. Naturally, there are doyens and very intellectual people who are behind such amendments. They have been taken into confidence. So I am sure there is a purport and intent behind this concept. We will have to see how the courts are going to interpret section 20 and how actually this section is going to work in practice. So section 20 is very interesting and we will have to wait and see how the courts are going to deal with. Now another section 20 subsection 4, if you see the old act, that was one section which gave discretion to the court to give specific performance. Normal rule was specific performance was an exception, damages was the rule before the amendment. After the amendment, rule is specific performance, exception is damages or compensation. But even under the old act, section 24, if I may say, was the only provision in the entire specific relief act which gave discretion to the court to specifically enforce a contract even when that party was not entitled to it. So section 24, if you see, let us read out section 20 of old act, section 24 as it stood before amendment. The court shall not refuse to any party specific performance of a contract merely on the ground that the contract is not enforceable at the instance of the party. This has been strangely removed, not put anywhere else in the act also, because this is very one important section which takes away discretion of the court. Even where the party contract is not enforceable, the court had the power to grant specific performance under old 24. That is in line with the amendments brought about under the new act. But strangely, I don't know whether it is on purpose or an accidental omission, 24 does not find a place. So this probably again we'll have to wait and see if the legislature wakes up and includes necessary amendments to the new act, or the courts may also step in and decide the matter. And 20 capital A, capital B, capital C are newly inserted provisions. They deal with a special category of infrastructure projects. Infrastructure projects have been set out in a separate schedule at the end of the Act. What are the categories of infrastructure projects? What are the subcategories? For example, transport, setting up of ports, setting up of electricity grid stations, setting up of railway stations, hospitals. All these are categorized as infrastructure projects. A separate schedule, which is explaining section 20, is added to the Act, setting out several categories of special projects which are categorized as infrastructure projects. So 20A, B, and C apply to such infrastructure projects, cases pertaining to infrastructure projects. 20A is dealing with infrastructure projects. 20B deals with cases, courts to be set up, special courts are to be set up to deal with cases, fast track cases pertaining to infrastructure projects. As on date, special courts are yet to be formed or notified. Then there is also a time limit of 12 months to decide any suit in relation to the infrastructure project. It can be extended for a maximum of 6 months. An aggregate of 6 months, it can be extended, but not beyond it. So they want to fast track infrastructure projects. Because the object of the amendment itself, one of the objects was, as I told you, the economy is very robust and the government wanted more investments to come into India from abroad. This is one of the objects. Therefore, in line with that, they want to showcase India as a where litigation is not going to bog you down or cause undue delays in case of litigation also. Therefore, this is an added advantage or incentive, you can say, to foreign investors and companies to come and do business in India with India. So this is 20A, B, C. 21, there is a minor amendment. Section 21 empowers the court to award compensation in addition to performance. Now, this is after amendment. Earlier, before amendment, it says either in addition to or in substitution of relief of specific performance. So there was a discretion vested in the court earlier. Either do a specific performance, I am going to decline relief of specific performance, but I will give you compensation. But now that is relief, discretion is removed. The section says in addition to performance, you can award compensation. Therefore, even if specific performance is being granted, court is still empowered to grant compensation. Then section 22 deals with the power of the court to grant in appropriate cases reliefs of possession, partition, separate possession of property in addition to relief of specific performance, or relief like refund of earnest money in case of refusing to. So the court is going to grant specific performance. Court has also power to grant additional reliefs like possession, partition, and separate possession. But court refuses to grant specific performance. It can additionally grant refund of the advance. But however, the section says it is mandatory that a requirement to plead such additional relief or alternate relief is made in the plaintiff. So that is section 22. And in fact, the power of the court to allow a party to amend the pleading is permitted even at the appellate stage. So at any stage of the proceeding, the plaintiff can make amendment and say, ask for the additional relief of partition if the case so warrants, or separate possession if the case so warrants, or the alternate relief of damages for use and occupation. In fact, Mrs. Chitra Sampath was also discussing this point. Recently, our High Court has taken the view that even if there is no pleading regarding the refund of advance, still the court on equity can grant. And that matter has been confirmed with the Honorable Supreme Court also. To my knowledge, I am not aware of that aspect, but it is definitely clearly violative of section 22 is what we can see. So section 22 clearly says, unless there is a pleading, even if there is no pleading, there is an option to amend the plaint. So you either amend the plaint and bring the additional pleading or alternate pleading to be entitled to such relief. So 22 is as it stands today. Of course, we can't find fault with the court doing equity. It is definitely fair and proper because you are saying we will not give you the property. You also forego your advance. It's not fair in equity. Therefore, let us not find fault with the approach of the courts in exercising discretion and granting relief, equitable relief. But it is not in consonance with section 22 is what I wanted to bring to your notice. Section 23 enables specific performance even in cases where liquidated damages is agreed upon by the parties. Suppose the agreement has a clause that in the event of default, there's an option for damages. Then the court says, no, not necessary. Apply section 23. You see, the intention was whether it was the default clause was only to enforce the contract, a threat to enforce the contract, or was it giving an option to wriggle out of the contract and pay damages? If go again, look into the whole contract and see what was the intention of the parties. Look into all the clauses. So therefore, just because there's a clause saying in default so and so will be paid, liquidated damages will be paid, it will not disentitle a person from claiming specific performance. Section 24 bars a plaintiff's right to sue for compensation for breach after dismissal of the suit for specific performance. However, it does not bar the right to sue for any other relief available by reason of such breach. For example, a suit for specific performance is dismissed. It's basically the principles of res judicata and order rule 2. Thereafter, you cannot claim compensation. The court has already said you are disentitled for claiming specific performance. You are not ready or willing, or you have come to court late, for whatever reason, the court finds you are not entitled to decree for specific performance. After dismissal, you cannot institute a suit and claim compensation against the original party on the ground of breach. That is section 24. But section 24 says any other right which he may be entitled to by reason of such breach is not taken away. For example, you can bring a case of refund of advance in section 24 also, in my opinion. Again, I'm thinking aloud because I may be very confident that my suit of specific performance is going to be decreed. So I go up to the end. I fight it up to the very end, fight up to Supreme Court. Unfortunately, I lose on technical ground. Can I not take benefit under section 24, which allows me to get other reliefs? I am not claiming compensation. I cannot claim compensation under 24. That is fair enough. But will I be disentitled to file a suit for recovery of my advance within 3 years from the date of my final adjudication in the suit for specific performance? So I am thinking aloud. 24, I think, will come to the rescue of persons who have chosen or omitted to sue for the alternate relief of refund of advance. Section 25 is a very minor amendment which says the compensation, it applies to the Arbitration Act of 1996. Originally, the act was 1963 Act, where the Arbitration Act of 1940 was in force. Therefore, they have now substituted the 1940 Act with the 1996 Act. So this chapter 2, which relates to specific performance of contracts, would not apply to awards in respect of contracts passed under the Arbitration and Conciliation Act. So if the contract is arbitrable or an award is passed, such awards cannot be specifically enforced under the Specific Relief Act. It also includes excludes the chapter, that is chapter 2, for directions in a will or codicil to execute a particular settlement. Suppose there is a direction in a will or codicil to execute a particular settlement, and you can't come to court to enforce. That is the exclusion of section 25. This section 26 sets out the instruments that may be rectified. It is possible to get a rectification by either party. Either the plaintiff or the defendant can come and seek the court approach the court for rectifying the instrument at the instance of the parties or their representatives of interest. Suppose there was a mutual mistake, which the parties agree, it can be rectified. Section 27 to 30 deal with rescission of contracts as to when it can be adjudged or refused, including the power of the court to require parties rescinding to do equity. So 27 to 30 is rescission, where party wants to withdraw from the contract. That is section 27 to 30. 31 to 33 deal with cancellation. 28, in fact, is very relevant. We have come across section 28 very often, where rescission is after the decree. There is a decree for specific performance. There is a condition which requires the plaintiff to deposit the balance sale consideration, say within 90 days. He does not comply with the direction. Then it is open to the defendant to invoke section 28 and seek for rescission and say this material condition has been violated. Then section 31 to 33 deal with cancellation instruments, when it can be ordered, whether partial cancellation can be permitted, the power of the court in this regard. Sections 34 and 35 deal with declaration. This already, I think, Mr. Chitra has taken in detail, but for purpose of completion, I will just quickly take you through the remaining sections of the Act. Sections 34 and 35 deal with declaration of rights of parties and discretion vested in the court to grant the same and effect of declaration. declarations to set aside documents or decrees, declaration to title of property, etc. will fall within the purview of these sections. Section 36 relates to discretion of courts to grant preventive release of injunction, temporary or permanent. Section 37 deals with the temporary permanent injunctions and the nature and scope. Temporary injunctions can be granted at any stage of the suit and for a limited time, either until further orders or for the next 2 weeks or whatever. These are temporary injunctions. But the permanent injunction is where the court applies its mind after trial and gives a final finding. It's a permanent injunction. The procedure is regulated under the CPC. Then section 38 deals with perpetual injunctions when it can be granted. Instances of such cases are when compensation is not going to be adequate, no standard exists for ascertaining damages, or where a defendant is a trustee of a property for the plaintiff, and to prevent probably multiplicity of proceedings also, injunctions can be granted. Section 39 deals with mandatory injunctions, positive injunctions, where a person is required to do a particular act. Mandatory injunction, section 39, to either to prevent breach or to compel performance, mandatory injunction can be granted. You see, section 38 is in injunctions sought under 38 are in restraint and may be termed negative. Section 39 requires a positive act to be done, therefore it will be positive. Section 40 entitles the person to seek damages in lieu or in addition to injunction. So this is again like section 32. It applies to 38 and 39. Both forms of injunction 38 and 39, a person can ask for damages in addition to the relief of injunction. Here again, like section 22, which we discussed, there is a mandate for the plaintiff to make a specific plea. Unless he makes a plea or a prayer in the plaint, he will not be entitled to the additional relief of damages. And here again, the amendment provision is available. He can include by way of amendment. How dismissal of a suit to prevent a breach of obligation bars the suit. It is again similar to what we saw. Once a suit is dismissed, under 24 we saw. Here again, if the suit for injunction is dismissed, you can't claim compensation for damages for breach. 41 deals with cases where injunction cannot be granted. There are 11 different illustrations set out in section 41. Now they have newly introduced 41H, which relates to infrastructure projects. The court is now asked to go slow in granting injunctions, which would impede the progress of an infrastructure project which is happening somewhere. You don't grant injunctions in cases of the infrastructure projects. This is one inclusion in 41 now. The Amendment Act after 2018. Section 42 empowers the court to grant a negative agreement. To perform a negative agreement, an injunction can be granted, even when it is unable to perform specific performance of an affirmative agreement. Therefore, the agreement consists of two parts. One is a positive part to perform specific performance. The other one is a negative part. The court can segregate that and grant a negative agreement. If it is express or implied, can be found in the agreement. 43 and 44 have been repealed by the Repealing and Amending Act of 1974. So therefore, one thing which you may have noticed is the discretion vested in the matters relating to declarations or injunctions remain. What is sought to be whittled down or scuttled is only discretion in chapter 2, which pertains to specific performance of contracts. The discretion vested in courts to grant injunctions, to refuse injunctions, grant declarations, all these remain. There is no change. But section 19, I think I missed out one aspect. I will just briefly take you to section 19. 19 saves. 19, we saw categories of persons against whom specific performance may be enforced. There is a clause which says against subsequent title holders also. So specific performance can be granted, enforced against subsequent persons who obtain title subsequently. Suppose an agreement between A and B. C purchases the property. The agreement between A and B can be enforced by A against C also. So if he succeeds, even C will join the execution of sale deed or as directed by the court to execute a sale deed in favor of A. Here, the only exception is if the purchaser is able to show that he had no notice of the earlier agreement and he was a bona fide purchaser for value. No notice of the earlier agreement or contract, and he is a bona fide purchaser for value without notice. So if these ingredients are satisfied, his contract is saved. So specific performance will be refused in such exceptional cases. It is for incumbent on the purchaser to establish that he did not have any notice. Then there are several cases. Suppose there is a tenant in the property So the purchaser, naturally, he will go and, suppose a tenant had an agreement to purchase. Let us assume a tenant had an agreement to purchase the property from the landlord. If a tenant is in possession, X purchases the property without verifying the credentials of the person in possession. If he had gone and made inquiries, he would have known. It may not be reflected in the encumbrance certificate. Once the agreement is registered, it will be reflected in the encumbrance certificate. Suppose the agreement is an unregistered one, it will not be reflected in the encumbrance certificate. So then it is incumbent on the agreement holder to make due inquiries, reasonable inquiries, as any prudent man would do, to find out whether there are any hitches, or he can proceed to purchase the property. This is section 19 exception, which is important, which I did not take you to. So now we have seen that there are really very important drastic amendments. Cases are yet to come up to the stage of high courts, and leave alone the Honorable Supreme Court. We are going to be very interesting to see how this section 20 is going to be interpreted by the courts across the country, and law will be settled very soon by the Honorable Supreme Court. But as I said, the amendments are with a very laudable object to project India as a very safe haven for investment. So it is but natural that you will have to say that even when there is a litigation, you will not be troubled. You will still come out quickly out of litigation. Your project will be through. This is the underlying object with which the amendments have been carried out to section chapter 2 alone. Section 20, as I said, is going to be worth watching. We'll have to see how the courts are going to decide. And in fact, I was just discussing with my colleague, giving the testing times of COVID-19, we have seen the policy shift of many countries to abandon their earlier projects or not enter into projects with a particular country and shift their investments to other countries. So I think probably hoping that this might be a boon for India, I think the amendments have come bang on time. Thank you very much for your patience. Stay safe.
Thank you, Mr. Balaji. Before going for questions, I want to have a question to be answered by you.
Sure.
See, section 16 has been amended now.
Yes, correct.
So there is no requirement of pleading, and the word "our" has been omitted.
Yes, correct.
Now my question is, unless there is a pleading about the readiness and willingness, the plaintiff,
yes,
there could be no defense of denial by the other side.
Correct.
So unless there is a pleading of readiness, willingness, and the absence of any specific denial, the chance of framing an issue is ruled out.
Will not arise, correct.
So how do you expect the plaintiff to adduce proof? Because the section is insisting still on proof of readiness and willingness.
Very true, very true.
So without an averment and a denial and the issue being framed, how do you expect the party to adduce evidence, number one? Number two, simply because the readiness and willingness or something is contained in the agreement itself, can we say that without pleading, evidence can be let in?
No, that is, I think that law is settled. Just because you cull out from the agreement itself, your readiness and willingness is not sufficient. You still have to plead and prove as the old Catina of judgments. But now you have a very valid point. I am with you on that. So it is still, I think it would be advisable. See, failure to plead, you will not run the risk of dismissal of the suit. But as you rightly said, it is better to still plead. Don't avoid pleading readiness and willingness. There may be an accidental omission, you can skate through. But don't take the risk of not pleading. At least not in the express terms by saying I am always ready and willing as we used to do. But at least from the plain pleadings, you must be able to cull out the fact that your conduct by giving a notice or approaching several times, that will indicate readiness. So there need not be the exact replication of the term readiness and willingness. Your plaintiff is able to show that from paragraph so and so, you have made out your readiness and willingness. That I think would suffice. But as you said rightly, it is safer to plead readiness and willingness.
So your advice to the councils on to always plead readiness in the plaintiff.
Better. Nothing wrong, no harm.
Okay. Now I think Mr. Anya Vijay is waiting on the line.
Yes, sir.
Just a minute. I'll just unmute him and let him.
Yes.
Lordship, Anya Vijay, Lordship, can talk to Mr. Balaji.
Yeah. Good morning, Balaji.
Morning, sir.
We all had the benefit of hearing your erudite lecture.
Thank you, sir. Thank you.
I want to say two things here.
Yes, Choloma.
According to me, even though as a judge I am not supposed to come up with my opinions here, but since it is more academic, I'll not. I'll only try to say this. See, even in the absence of the word "our," under Section 16, the law is now well settled that even where you don't use the word readiness and willingness in the plain, it is always possible for the court to gather such readiness when in substance such pleading is available already in the plain. There are decisions to that effect. So therefore,
express reproduction.
Yeah, there was a school of thought earlier where they will be searching for this word readiness, unwillingness in the plaintiff. If that is not there, that itself will be put against the plaintiff. Thereafter, there was a change in thought, and now, at least as of even assuming that there is no such amendment, if in substance the amendments made in the plain establishes readiness and willingness, I think it is enough. That is how the courts have interpreted. That is number one.
This answers Srinivas Raghavan's question.
Yes,
I get the answer.
That is number one. Number two is that according to me, specific relief for performance of agreement of sale even today continues to be an equitable relief. The amendment does not take away that nature, because Specific Performance Act by itself is a law of equity. Therefore, it is an equitable relief. Therefore, the equitable relief will depend upon the plaintiff being ready and willing to perform part of the contract right from the date of the contract till the date on which the. So, when that is there, even though Section 16 has removed the word "our," that does not mean that you will not say anything with regard to your
readiness.
That does not mean that you will not plead anything on your readiness and willingness, because what happens is ultimately when you are leading evidence, you cannot lead evidence in the air without there being a pleading for readiness and willingness. And readiness and willingness in turn it becomes mandatory because it is an equitable relief. So I think basically what 16 did was that it removed this technicality of repeating this word readiness and willingness in the amendment. But in substance, even now, I think it is important to make out a case that you were ready and willing to perform your part of the contract, since this continues to be an equitable
requirement.
Yes. One. Two is you were talking about Section 20 of the Act. Section 20 of the Act, as you rightly say, that there is that provision which gave the discretion to the court is now missing. Missing. But what I am trying to say is that unless and otherwise you say that the relief of specific performance is no more an equitable relief, that discretion that is vested with the court will continue. Whether you put it in the enactment or not, because the nature of relief is such that it is a relief that is based on equity. Based on equity. So it's true that to a great extent that discretion has been whittled down, has been brought down, but I think that it has not been completely taken away. Not as if the judge will act like a computer. You will put in something, if it is satisfied, you will say yes, it is taken. So if that is the case, then the whole nature of the claim of a specific performance gets diluted. It continues to be an equitable relief. If it continues to be an equitable relief, then discretion that is vested in the court must continue. Of course, you cannot use the discretion to the extent to which you were using earlier, where even if everything is satisfied, suddenly the court says, no, it is okay if this is done, or probably that cannot be done. But according to me, that element of discretion, I think, may continue.
True, very true, sir.
So, and the third thing is on the issue of retrospective and retroactive. See, many are now confused with regard to the one second. many are now confused with regard to the operation of the amended act for the pending proceedings. What happens to the pending proceedings as of today, which were filed even before the coming into force of the Amendment Act? So that is one question which you have to address. Or else I have nothing more to add, and it was a really wonderful
Thank you, sir.
presentation, Balaji.
Thank you so much. So as for pending proceedings, I will straight away answer. The Act came into force on 1/10/2018. So if it is going to be applying Bajpayee's case and IndusInd Bank's case, the principle of retroactive theory, the pending suits on the date of the amended Act coming into force is only the old Act which will continue to apply as if it is not amended. And the unamended provisions will apply to pending suits as on 1/10/2018. That is suits filed before 1/10/2018. But if a suit is filed after 1/10/2018, even though it may relate to an agreement which is prior to the amendment, even then the new Act, the amended Act will apply. That is the essence of my summary of what I had stated earlier.
For the advantage of the viewers, why
Yes.
don't you also explain what is retroactive?
Retroactive, yes. Retroactive, originally there are only two sides to the coin, the retrospective or prospective. Whether the application of the amendment will be retrospective, meaning it will apply to pending proceedings. If it is prospective, it will not apply to pending proceedings. It will be henceforth applicable. That is prospective. But retroactive, what the Supreme Court said is there are cases like an example which I just gave you, where an agreement may be prior to amendment, but litigation may have started after the amendment. So then that is the approach which Supreme Court says retroactive. It is retrospective in the sense that it will apply to an agreement entered into before the amendment, but prospective in the sense that the new Act will apply. So this is retroactive.
In fact, the meaning of retroactive is, you will find the meaning in the Vodafone case that was decided by the Supreme Court. The retroactive actually means, it's a very, very dangerous concept. The retroactive actually means that even though you have filed or a proceedings has been initiated or you have filed some case, retroactive means that even though the Act came into force subsequently, which has changed the entire structure, that changed structure must be read into an existing case. It has to be read into an existing case as if this was available even as on the date it was. That is what retroactive means. So therefore, if for the pending proceedings, if this is done, as you rightly say, that it all depends upon how it is going to be interpreted in the coming days. Okay, well, you can address the other questions of the viewers.
Thank you.
Thank you.
Mr. Balaji,
Yes, Chalma.
what is actually meant by section 16C as amended according to my humble opinion?
Yes.
You may find appendix A to CPC. Now there are specific forms of pleading readiness under form 47 and 48.
Correct.
There are some judgments which says that if the pleading of readiness is not in consonance with form 47 and 48, it is not.
It is fatal. It is fatal.
That vigor is now taken out, we may say, in such a way also.
Correct. Yes, you are right. That is the interpretation we should give.
Thank you, sir. Regarding retroactive, I find that I would draw a comparison.
Yes.
You may take section 6 of the Hindu Succession Act, where the Parliament has exempted a partition on a particular date. For example, it's the date of introduction of the bill in the Parliament. From 21/12/2004, if there has been any partition deed, they are not saved. So can we say that section 6 is retroactive in that particular aspect? There can be such comparison?
No, I think the comparison does not arise because in this case, the Act is silent. In that case, what is the cutoff date?
So retroactive must be the declaration of the court. I understand.
So here where there is a lacuna in the amendment saying whether it will apply prospectively or on a particular date from a particular date. That is where the issue comes up. The retroactive, whether it is prospective or not.
But normally all the acts are prospective, all judgment are retrospective.
All substantive laws are prospective. procedural laws are retrospective. Is
Retrospective.
what has repeatedly held.
Okay, sir. So Justice Namamutu J is waiting in the line.
Yes.
So SNJ sir, you can talk to PB.
Yes, yes.
Morning, sir.
Yes, good morning. It was a good lecture.
Thank
Really
you, sir.
enjoyed. Now, I was hearing what Honorable Justice Anand Venkatesh was saying. I want to say that I got a different kind of understanding of the discretion. Now,
Okay.
it was all along the discretion of the court to grant relief was found in Section 10.
Correct.
As amended.
Yes.
True.
Now, Section 10 has been amended.
But shall
Discretion has been removed, and it says that it shall be enforced, which means, in my view, the court has got no discretion at all now, as per the amended Section 10. Please kindly look at Section 10 once again. The word discretion.
But exceptions 11, 2, 14, and 16. Okay.
Okay.
So that
No,
is
subject to.
other discretion.
That's what one. No,
Under 11,
that
2,
is not
14,
discretion.
16, it will be a discretion. Otherwise, mandate.
No, please wait. This is not discretion.
Hmm.
So earlier, section subject to subsection 2 of Section 11 and Section 16. Okay?
Yes.
So this is a condition.
Correct.
If these conditions are available, then you cannot grant, because there is no more discretion. It is a condition. Discretion means having come to the conclusion that the party is entitled for
I got it. Correct.
So if the court is given a discretion not to grant that, so it was available under Section 10 in excess of the discretion was there. Now these are all two conditions. So the court shall grant enforcement
Shall be enforced.
Yes, decree for specific performance shall be granted subject to these conditions contained in subsection 2 of section. I don't have the book. Just
Subject to provision. I'll
yes,
read
yes.
Section 10. The specific performance of a contract shall be enforced by a court subject to the provisions contained in subsections 2 of Section 11, Section 14, and Section 16.
That's all. See, earlier here what was there in Section 10 as originally? We kindly read that original provision.
Whole portion, except as otherwise provided in this chapter, specific performance of a contract may, in the discretion of the court.
Yes, may in the discretion.
Yes. That has been removed.
Yes, may in the discretion has been now done away with.
Shall.
Now it says shall.
Shall.
But it puts two conditions.
Correct.
Subject to these conditions. If these conditions are satisfied, you don't have any jurisdiction at all, no discretion at all. So you are bound to give. Okay. So what I feel is, with great respect, that the discretion which was available for a court to refuse has been done away with. Number one. Number two, as you pointed out, what I feel is that I gave this lecture to in some other group also, where I very emphatically, referring to various judgments, I very emphatically said that this amendment is only retrospective.
Retrospective.
Yes, because there is no intention otherwise shown in the act itself. It is retrospective. So in respect of the matters which are pending for even for the Supreme Court now, this can be applied. These two important changes. Number one, in a case where either the trial court or appellate court has refused to grant decree using its discretion, now applying this amendment, the Supreme Court is bound to reverse it and to grant decree, subject to the other condition like Section 14(2) and Section 16. Okay, number one. So this is no more it's not prospective, it is only retrospective. This is what I sincerely feel. Secondly, discretion has been done away with. You don't have the discretion. This is what and thirdly, I think that Mr. Srinivas Rao also asked that question. Section 16C has been amended. Now, what does it say? You need not plead specifically that you are ready and willing. As it was very rightly pointed out by Honorable Justice Anand Venkatesh. So these specific words need not be there. We have to gather whether such a sufficient pleading is available or not. That is enough. Now, amended act says that there need not be any pleading. Well and good. But it says the readiness and willingness used to be proof. I got my own doubt, and we have got the well-established principle that unless there is a plea,
there is no proof.
There is no proof. There has to be a plea, and it should be disputed When it becomes a dispute, then there is an issue. When there is an issue, there is evidence available. The evidence, no, nothing is available.
It cannot be, can't be an
Yes,
issue.
so therefore, what I feel is 16 C, even after this amendment, is to be read, as it was pointed out, that there has to be a pleading, there is to be a dispute, there has to be issue, and there has to be evidence letting thereafter only. Otherwise, courts won't allow evidence to be letting. This is my humble view. I do not know what you feel.
Probably the legislature, you may be right. Probably the legislature only said do away with the form, pleading in the form.
Yes, yes. That's all.
The pleading one, you don't reproduce that. That is not necessary.
Thank you very much. Thank you very much.
Thank you so much.
Very good lecture. Thank you.
Thank you so much, sir. Thank you.
Thank you.
Mr. Sir, now it's time for the questions raised by the parties.
Yes,
I request Ms. Gayatri to ask questions to you. Ms. Gayatri.
Good morning, sir.
Morning.
Good afternoon, sir.
Good afternoon, Chulma.
Sir, I've got about 3 questions.
Yes.
First one is, what happens to the evidence during substituted performance of a contract? And how will readiness and willingness be proved when there is a substituted performance of a contract? That is the first question. The second one is, if there is a clause in the contract, the 10% is damage to breach, does that amount to liquidated damages? And my third question is, if the contract does not specify sale consideration, is it a valid contract? I have one more question, if I can raise that also, the fourth question.
Yes.
If an ancestral property is subject to a contract without other sharers signing it, can a court suo motu permit for partition, or should I raise that as a release and amend my plaint and thereafter go ahead with partition? Then
Yes, I will answer in reverse. Section 22 is the answer for that. If you want partition, you must plead. You must ask for a prayer under Section 22 for any additional relief. So without pleading, court is not going to give you a partition. That answers your last question. Last but one, liquidated damages. There are judgments which say, even the section says it is not a bar. Just because the sum is fixed as a liquidated damages, it will not disentitle you from seeking specific performance. As long as you show the court that the intention was not to give an option to the defendant to pay damages in lieu of specific performance. That is one. That answers the other question. The first question, substituted performance. See, according to me, there are no case laws, as I already told you. According to me, my interpretation would be question of readiness and willingness will be alien when it comes to specific performance, substituted performance. See, once the contract is breached, you need not go to court. You are going to go to a third party, get the contract enforced by substituted performance, and come back only for claiming damages. So what all you have to prove is breach. When you claim damages or costs from the original defaulting party, what you do is you will have to plead that there was an agreement, the defendant breached it. As a result of it, I gave him the statutory notice. In spite of the notice period, he did not come forward to comply with the obligations. Therefore, I opted to substitute and perform the contract through a third party that has been completed. To plead about that, then say what are the expenses and costs incurred as a result of that, and claim it. So the question of readiness and willingness will become alien. What was your second question?
What is if the sale consideration is not specified in the contract?
Sale consideration is not fixed. If there are two ways of looking at it. Yeah, consensus ad item is the fundamental for any contract to be complete. So unless the parties see eye to eye on a particular material term, the contract is not complete. It's not a concluded contract. So if suppose there is nothing to gather from the sale agreement that the sale price has been fixed, then the contract definitely cannot be enforced. But suppose some of the terms, there is an indication that this will be the price at the rate of so and so. Suppose you are able to make out that this will be the sale consideration, that contract can be enforced, in my opinion.
So if there is no sale consideration specified, then such a contract is an invalid contract.
Definitely. It will be a defense under Section 9 for the defendant to say that we never agreed on the price. You can't enforce this contract.
Yes, sir. But there is a case law that says that if the sale consideration is also not been specified, it is still a valid contract in as much as the parties agree that at a later stage that they would be able to pay the exact same price that has been fixed at that point.
So that is why I said, if you can cull out from the terms, that is exactly what I told you. If you can cull out from the terms of the agreement, even if there is no sale consideration, that contract can be enforced, not otherwise.
Yes. Okay. Thank you.
Welcome.
Thank you, Ms. Gayatri. You can unmute yourself. I'll go to the next person. Next person is Mr. Adarsh Subramanian. Mr. Adarsh.
Yes, sir.
Morning, Adarsh.
Hello, sir. Two questions, sir.
Yes, Cholma.
First one is with respect to section 22, 20 subsection 2, how do you reconcile the requirement of 30 days and the portion which is within such time as specified in the notice? Does this mean minimum 30 days notice plus?
Correct. Suppose you may choose to give 60 days.
60 days notice.
If you give a notice for 60 days, you wait for 60 days. But minimum of 30 days notice is mandatory.
So that brings me to my next question.
Yes.
What if a party suffering a breach cannot afford to wait for 30 days? What if his requirement is within the first 2 weeks? And if I am to give 30 days notice, the whole purpose is becomes odious.
True, maybe. But what is the remedy otherwise? So you will only have to file a suit for specific performance. You don't want subjected performance. You have to go to court. That will take years together. So are you not better off waiting for 30 days and file a suit for do it, perform the contract by substituted performance? You are not going to court. You have the option of performing the contract itself after 30 days. So I think you are better off. As you said, if there is an exigency, you may have to put up at least minimum 30 days.
Okay. Thank you, sir. Thank you.
Thank you, Mr. Adarsh. You can unmute yourself. I just moved to Ms. Jessie Jivapriya. Jessie Jivapriya, ma'am, you can talk to P.B.Balaji.
Yes, sir. Good afternoon, sir.
Good afternoon, madam.
Sir, I had a regarding section 6, sir. Section 6.
Yes,
I have told that the person, sir, who done can also move the court, sir. Not only who is dispossessed, but also who dispossessed him can also go to court. Not only.
Subsection 4 says,
Yes,
nothing in this section shall bar any person from suing to establish title and recover possession. It will not come under 6.
Regular suit. Yes,
Regular suit, not under 6.
Not under 6.
It will not be under 6.
Thank you, sir.
Thank you, Jesse. You can unmute yourself. I just moved to Mr. K. Hariharan. Mr. Hariharan, sir. Mr. Hariharan. Okay. I will move to next person, Mr. Venkatraman. Mr. Venkatraman.
Sir, good afternoon, sir.
Good afternoon, Venkat.
As always, a lucid presentation.
Thank you.
Two quick technical questions, sir.
Yes.
It's about section 14, both under the new act and under the old act.
Okay.
Under the old act, it was 14(1)(c).
Okay.
A contract which is in its nature determinable. New act, I believe it is 14D. Yes, sir. So my question is, what is the test to determine this? How do we come to a conclusion whether a contract is determinable or not? A mere presence of a timeline. Let's say this contract is enforceable within 30 days, 60 days, or 90 days. Is that alone sufficient to decide whether the contract is determinable or not?
I think it is a question which will have to be decided purely on facts and circumstances. Suppose let us take a case of a lease agreement. It is for a period of 3 years. An option is given to either party to rescind the lease, terminate it at the earlier point of time by giving 3 months notice. That is an express clause which will come under a contract which is nature determined. If the parties agree that it can be determined, so that contract can't be enforced. So there's an option available. See, basically the court is only enforcing what the parties have agreed in letter and spirit. So when the court itself, the parties themselves agree that this contract can be put to an end by giving a 3 months notice, the court will not step into that domain and say, no, irrespective of the notice period, you have to perform. So that is what, in my opinion, will be the interpretation should be given to 14(1)(d). As you said, express or implied. The term may be expressed, conduct may be expressed or implied from circumstances of or conduct of the parties. The court has to decide purely on facts and circumstances of any given case, whether it is a contract which is in nature determinable.
Perfect, sir. But will the court, even assuming one of the parties who had terminated the contract has given a proper notice, let's say 3 months notice,
Yes.
will the court in a suit for specific performance get into the fact whether the
Yes, it has to,
termination
it has
is
to.
wrongful or not?
It has to. Definitely, incidental question will have to be gone into.
Whether it is a wrongful termination or right?
Yes. If it is a wrongful termination, court will proceed next to give you specific performance.
Great, sir. Great.
Yes.
So my second question is, as we know, Tamil Nadu registration section 17.
Yes, has been
In Tamil
amended.
Nadu, it was amended to make agreement to sell to be compulsory registrable from 1/12/2012.
Correct.
So as we all know, an unregistered agreement there cannot be used as an evidence.
Correct.
The only exception is proviso to section 49.
Correct.
That says two provisos. One is collateral purposes it can be used. Second is an agreement to sell for specific performance.
Correct.
So even assuming there is a 2015 or 16 agreement to sell and it is unregistered, can it be still enforced? Can I still file a suit for specific performance?
In fact, our court, in fact, Justice Anand Venkatesh has decided this issue in 2019 6 CTC page 580.
Okay.
Following the ratio laid down in 2019 2 CTC page 530. Justice Seshasai. They went into this. Both the judges have independently assessed the impact of the amendment to section 17 and reading 49 along with that. See, 49 has not been amended. You see, 17 has been amended, including agreements of sale to be registered. But the exemption under 49 continues. That weighed in the mind of the learned judges. 2019, 2 CTC page 290 is Justice Seshasai's judgment. 2019, 6 CTC page 580 is sitting in the Madurai bench. Justice Anand Venkatesh has given the later judgment. With both of them say that the agreement, in spite of not being registered, can be enforced by.
Great, sir. Thank you, sir.
Thank you.
Thank you. Get someone, you can unmute yourself. Now let's move to Mr. P.V.S. Giridhar. So Giridhar, sir.
Right. 1 minute.
No, sir. Good afternoon.
Good afternoon, Balaji. It was really great listening to you. I was telling Srinivas Raghavan how in these seminars we are getting a global view of various. We all know section 14, section 34 and so on, but it was really enlightening listening to you. I just have 2 comments. One is with regard to the amendment in section 16, where the word "our" has been removed. One can also interpret the amendment as removal of a redundant provision. When the law is well established that there cannot be any pleading evidence without pleading, government is a redundant provision. Therefore, it has been eliminated. One independent amendment, which would fall in line with the views expressed here in respect of section 16. Then, in respect of section 20, Justice Nagamuthu opined that it would be retrospective. Now, this is a provision which removes the dispute of the court and therefore pertains to a power of the court, which is a substantive provision. So, unless the Amendment Act itself said that it's retrospective, in my opinion, it cannot be retrospective.
Be prospective.
Definitely be prospective.
I hold you.
That's my understanding. With due respect to Justice Nagamuthu. That is all. I just had these 2 comments and appreciation. Thank you.
Thank you so much.
Thank you, Mr. Giridhar, sir. You can unmute yourself. Let me just move to Mr. Amog Sinha. Mr. Amog.
Myself.
Good afternoon.
Good afternoon.
Sir, my question is under section 20, there is a procedure of 30 days giving notice. 30 days. But what if that party does not comply with the procedure but proceeds with substituted performance? Will the other party have a remedy, something similar to damages for wrongful termination or something?
Again, this is all new concepts which we'll have to see how the courts are going to interpret. In my view, the section is very clear. It's the defaulting party to comply with the obligations within the notice period or 30 days, depending on which is opted by the aggrieved party. Suppose if the breach continues even after that. See, I will draw a parallel. In the old Tamil Nadu Building Lease and Rent Control Act, there was a provision which said if the tenant continued to default even after a 2-month notice, there will be a presumption that the default is willful. So the landlord need not go further. The presumption court can straight away draw the presumption that default will be willful if the default continued after a 2-month notice. So similarly, I think if the strict rigor of the act, if we go by it, the notice period is the final notice, which is final opportunity given to the defendant to either do the obligation required of him to do it or run the risk of substituted performance. So he cannot allow grass to grow under his feet and thereafter complain.
No, but that is when he is given sufficient opportunity. What if he is not given the sufficient opportunity at all?
Yes,
he still have any remedy?
100%. That also I think we discussed. Suppose the notice is invalid or the 15-day notice is given and substituted performance is opted. Definitely he has the advantage of questioning that by way of a separate suit.
Okay. Thank you so much. Thank you.
Welcome.
Thank you, Mr. Ambo. You can unmute yourself. I'll move to Mr. Sauminarayan. Sauminarayan? Sorry.
Hello.
I'm Sauminarayan. You can talk to Mr. Balaji.
Hello, Balaji. How are you?
Good afternoon.
Good afternoon, Balaji. Good afternoon.
Good afternoon. Yes, I'm able to hear you. Solomon.
Yeah. You say there is a difference between retroactive and retrospective.
Correct.
But there is no such that.
It is. See, retrospective na, it will apply to pending proceedings also. Prospective na, only henceforth, only cases filed after the date of amendment, prospective. Retroactive na, it will apply to contracts which were entered into prior to the amendment. Suit you are right. It will be date of institution of the suit, which will be the deciding factor.
What is the law? It will be governed up to the logical end.
Yes, exactly.
The next one is the Supreme Court has stated in Chandrachud judgment in 2019 One Law Weekly. The amended section has been notified on 19th September 2018 and the central government has appointed 1/10/2018 as the date which the provision of Act came into force, will come into force.
Correct.
But unfortunately, the Supreme Court has said, however, in the present case, we are not called upon to examine the effect of the amended provisions.
Yes, so far it has not been tested.
It was not judicially tested.
No, not so far. It will be tested. 100%
it will be tested. Then what is
we
the
have
effect
divergent views even in this session? We have got divergent views. And matter will be taken up to the Supreme Court, and or the High Court at least will decide as at the first instance or some of the High Courts. Then we will see.
Thank you, Balaji.
Welcome, sir.
Okay, Seminar, sir, you can unmute yourself. I'll move to Miss Ramya Leo. Ramya Leo.
Yes, sir. Sir, the previous question he asked my doubt actually. Sir, good afternoon, sir. Balaji, sir. It was a wonderful lecture, sir.
Thank you.
Swami, sir, he asked my doubt actually. And can you just give me the difference between a retroactive and retrospective? Any two instances, sir, please?
Example, yes. See, take a case of an agreement which is dated 1/1/2016.
Yes,
the agreement of sale is dated 1/1/2016. The act came into force on 1/10/2018. Suppose if the suit had been filed before 1/10/2018, the old act will apply. The unamended provisions will apply.
Okay.
But suppose the agreement is still 1/10/2016, suit is filed in January 2019, then the new act will apply. The amended provisions will apply. That is what is called retroactive, because the contract is before the amendment act came into force, but the institution of the suit or starting point of litigation is after the amendment came into effect. Therefore, apply the new provisions. That is what the Supreme Court says is retroactive.
Yes, sir. Thank you, sir.
Welcome.
Let me just try anybody else line. Mr. Vikram Jain. Mr. Vikram Jain.
Good afternoon, sir.
Good afternoon, Vikram.
Excellent session, sir.
Thank you,
sir.
sir.
I had one doubt with respect to section 20, subclause 2.
Yes.
In case of, say, immovable property, where I am not looking for substituted performance at all.
Okay.
I am pleading for specific performance of the suit.
Then why do you go to 20 at all? 22 or
then the notice period is not required. Then
only if you give up the right of specific performance and say no, I don't want specific performance, I will opt it, I will buy it from Bharat. You want to buy the property from Bharat instead of Balaji, then only you invoke 22. Suppose you only want to enforce the contract against me, you go under normal provisions of the act. the question of application of 20 will not arise.
Okay. Thank you, sir.
Thank you, Mr. Vikram. So I think we are coming to the end of the session.
Okay.
And our heartfelt thanks for you for the meticulous preparation, and more importantly, the lucidity in which you have narrated the sections chronologically, and very importantly, the way in which you have attended the interactive session that makes the webinar today is very special, and a very special thanks to you. Thanks a lot.
Thank you, sir. Always welcome.
Thank you.
Thank you.
Thank you. Thank you. Thank you, sir.